ফাইনালটা ভালো করে ও টিমের টপ দেখাই সেট তোমরা ঠিক করে এটা সেলফের টপি না এটা তো লাইভ হচ্ছে
May it please the Honourable Court, the counsel for the petitioner humbly seeks to address the bench as your lordships. Highly obliged, your lordships. Your lordship, would you like us to present the facts of the case in front of the court? Or directly turn to the issues? Your lordships, the first issue that stands before us is the PIL filed under Article 32 by Jeevan Jagrukta Abhiyan maintainable or not? My lordships, the PIL filed under Article 32 by Jeevan Jagrukta Abhiyan is very much maintainable because the petitioner is a public-spirited organization. As we have seen in SP Gupta versus Union of India, where the court held any public-spirited citizen or organization can file an PIL on behalf of the affected person if they are unable to approach the court themselves. The respondent states that the PIL under Article 32 of the Constitution, the concept of locus standi, the right to bring a case to the court, is relaxed. In PIL, any member of the public interest can approach the court to seek redress for a public wrong or injury. This allows for addressing violation of fundamental rights and statutory provisions, especially for vulnerable groups who are unable to approach the court themselves in good faith and sufficient interest. Varnath, being a huge tribal population and lacked the ability to approach the court, Jeevan Jagrukta Abhiyan, on behalf of them, had filed the PIL, which is completely maintainable. My lordships, if you allow us, we would like to proceed to the second issue.
Do you think that it is a PIL for the public interest or just a private activism?
No, your lordships, this is clearly a PIL, as Jeevan Jagrukta Abhiyan is a societable. Suppose the society, they have the complete locus standi or the intention of good faith that they want to protect their environment on behalf of the tribal people.
Whose interests have been violated?
So, your lordships, the tribal people's interests have been violated.
And is this person who has been arrested is a representative of those tribal people?
Yes, sir. Yes, lordships. He is the tribal leader.
The tribal leader. And do you think this case is maintainable just because the tribal rights have been violated? Or your individual client's rights have been violated?
In this case, both of the rights have been violated.
Both the rights have been violated.
What is axial popularis?
I'm sorry, your lordships.
What is axial popularis?
I'm not aware of
it.
it.
Embedded in this case.
So, if it's axial popularis refers to the action taken by Mahavir Arava, then I don't think, because the public speech that he...
Only is it the action taken?
He gave a speech on behalf of the tribal people.
What is the concept of being based on? It is based on axial popularis. So I am asking that what is the axial popularis here? You are telling the P is maintainable.
Yes, yes,
emanates from the Roman law. Axial popularis. So what is the axial popularis here? What are the parameters? What are the parameters of P which you are finding that they are being incorporated here?
Yes, your lordship. Jeevan Jagrukta Abhiyan filed the PIL on behalf of Mahavir Arava, who was arrested and detained for 24 hours, and he was presented before the magistrate. But his arrest, your lordships, it was non-maintainable because just mere he just mentioned his thoughts about, and in a stage where his country and his people are in danger, the displacement is on the stake. The PIL, the speech given by Mahavir Arava is very much maintainable.
What are the other alternative remedies you have exhausted before approaching Article 30?
10 minutes left.
Your lordship, Mahavir Arava first applied for a bail in the High Court, which was denied on the basis that he was an activist, environment activist, which has no proper link to him because he is just a tribal leader and not any political leader.
Environmental activists are not granted bail.
Sir-
Environmental activists are not granted bail.
So if the case doesn't support, so then
Why would the case not support? If
So
someone
in-
is an environmental activist, like suppose K. Modavarman was an environmental activist, Medha Patkar was an environmental activist. So if they are arrested, they won't get bail.
Your Lordship, giving the applying for the bail, and the bail is complete discretion within the court's decision. But according to the case here, Mahavir Arava is entitled to a bail.
What sections of PNS was being violated in this particular case?
Yes, Your Lordship. Taka, wait. 2 minutes, Your Lordships. Your Lordship, Section 113, promoting enmity, 152, Act endangering sovereignty, in reference to IPC Section 153 and 505.
Are they relevant sections?
According to BNS, if there is no proper evidence that Arava has directly.
My question is, are they bailable sections? Are the offences bailable or non-bailable?
So, according to my knowledge, yes, sir. Yes, Lordship.
They are bailable.
If they cannot be proven with adequate.
That has nothing to do with bailable and non-bailable. If they are proved or not proved. If they are charged with a section that is non-bailable, it is non-bailable.
Proceed with the section.
Lordship. The second issue, whether the SISZ project violates fundamental rights under Article 21, 19, Clause 1, Subclause G, and 14, and should be halted on constitutional grounds. The present petition, here, Your Lordship, gave concerns regarding the constitutional validity of Samriddhi Industrial Smart Zone. Approved by the Union Government of Indrayana, the project, which was aimed at economic development, causes mass deforestation, leading to displacement of tribal community. Your Lordship, the Chipko movement here in the 1970s was a forest conservation movement that originated in the Himalayan region. Here, it involved the villagers embracing the trees to prevent them from being cut down by the contractors and logging companies, protecting over 1 lakh trees from the deforestation. It is a big example that every project intended at tribal communities does not equal to sustainable developments. The violation of Article 21, the right to life of the Constitution, includes right to a clean, safe and healthy environment. Here, Your Lordships.
Under which case it has been established that right to life includes right to healthy environment?
Article 21, Your Lordship.
Which case?
Article 21 expressly does not say that there includes right to healthy environment or right to privacy or right to shelter, right to livelihood. Nothing has been mentioned. All these are part of judicial activism.
This case has been taken from Subhash Kumar versus State of Bihar. Then the right to life and clean environment, the Article 21 of the Constitution includes the right to clean and safe environment. It is very well known to us that from the ancient age, humans have been relying on forest and know how to keep a balance of all the works and relying on the forest and supporting their livelihoods. But now the unbalance of projects like SISZ and development activities, which mostly rely or mostly support economic growth rather than sustainable development, these activities have declined the forest health, Your Lordship. Violation of Article 19, the SISZ project directly displaces over 40 tribal settlements without consent or rehabilitation. Those people relied on forests for cultural practices for their livelihood as well, which were also violated.
How far the Forest Dwellers Act is impacted by this?
Your Lordship, the forest dwellers are, most of them are tribal people who have no right to outer side of the world, which the SISZ project is offering to them. Without a proper information and teaching them how this has to work with their life, the direct connection is not shown to them. Hence, the tribal people are going to face a lot of problems in the future with the SIZ project. Here, they will probably bring out people who are already trained and give them employment here. With the tribal
But
people,
there are n number of cases where the court has admitted that development comes at the cost of some sort of environment. N number of cases is there.
yes, sir.
You can go for Narmada Bachao versus Union of India. You can go for rural education in India.
But
Environment comes at a cost of development comes at a cost of environmental degradation.
yes,
But you
sir.
do need to check on the intergenerational equity that needs to be maintained in cases of development. So how would you define this in this particular aspect?
We agree that every development costs us something, but according to the Chipko Andolan, as we remember, 1970s, there also
Is Chipko Andolan precedent for us?
no, sir, but it is a very important matter for forest and development rights.
It was social movement, as far as I am
Yes.
concerned. It's a social movement out of which certain litigations follow. What should we take into consideration from Chipko Andolan?
That not all the development activities that are shown will develop the area are always not developing the area. Probably, if the SISZ project is approved, then after a certain period of time, more looking at the urbanization SISZ would create, more other companies would like to start their projects in that tribal area.
But that is why EIA notifications is there. That is why environmental impact assessment is there.
Yes, sir, but the EIA has not disclosed any of those information or feasibility studies to the public. As I said that the tribal people need to have a knowledge of what they are going into or what they will be facing in the future through the SISZ project. It is important to be teaching them what it would show, but the EIA has not disclosed any of those informations.
In this particular case fact, it has been said that no information has been disclosed to the public.
Yes, Your Lordship. Your Lordship, my co-counsel will be following up with the issue 3 and 4.
Your Lordship, the next issue is whether Mahavir Arawa is entitled to bail in the light of the statutory restrictions under UAPA and the scope of Article 19(1)(a) in this case. Your Lordships, in this case, Mahavir Arawa is very much liable and entitled to get a bail under Section 43(d)(5) of UAPA. Mr. Mahavir Arawa was delivering a peaceful speech. It concluded with the slogan "Jungle Hamara, Faisla Hamara," a legitimate expression of tribal self-determination. The Honorable Court, in the case of Shreya Shingal versus Union of India in the year 2015, held that only speech that incites imminent lawless actions can be restricted. So, in the absence of any proven statements regarding incitement to violence or concrete link to terrorist activity, the inconvasion of UAPA provision is excessive and disproportionate. As it is held in the Union of India versus K.A. Najib that constitutional courts are empowered to grant bail despite Section 43D, especially when continued incarceration violates fundamental rights stated under Article 21. Sir, my Lordship, in this case, the petitioner emphasizes that no act of violence or direct link to the terrorism is alleged. In Mr. Mahavir Arawa's case, no arms were recovered, no incitement to violence was seen. Only vague allegations of contacts with activist networks were stated in this case. Also, the intelligent report merely mentions digital contact with any environmental networks, two of which are flagged but not banned entirely. This does not satisfy the high threshold required under Section 18 of the UAPA Act.
Can you tell the speech, apart from that slogan, what was the crux of the speech which he gave there?
Sir, he stated Jungle Hamara, Faisla Hamara, and also stated that
जंगल हमारा फैसला हमारा.
Yes, sir.
So how can you do the फैसला हमारा? How can you do फैसला? You are telling that it is a peaceful. So isn't it smelling about certain abatement of certain offences or instigation of certain offences that फैसला हमारा? How this word फैसला हमारा protects rule of law?
So this particular statement doesn't protect any rule of law, and it might be a little violative, but in the
You are
present,
admitting that it is violent.
so in the present case, Jangal Hamara, Faisla Hamara is legitimate as he is.
But you said it is self-determination. Just some time back you said that it is the mark of self-determination. And I would ask you, how would you differentiate between this particular statement as a self-determination and dismantling the governmental system?
So it was never dismantling of government statement, as he
But
was.
the government was there to take the decision, and when he calls upon for Faisla Hamara, that itself shows that he is not happy with the government and he is not willing to follow the governmental decisions.
So because he was representing the tribal community, people who
There
didn't.
was always a scope for deliberation.
Yes, so there was.
So,
But
how would
he.
you differentiate that this is just a mere self-determination and not a
Validated speech.
complete rebellion against the government?
So it was not a rebellion against a state, as because there were no violence involved in this. Though I must admit that after.
Only violence makes an offense. Only use of violence makes an offense. Then what is the difference between the calculative offense and the creation of violence?
There are certain categories of crime for which you are punished for only preparing for those crimes. You don't have to commit those crimes.
Yes, sir, but there is no evidence against that he was preparing or he was.
But in his speech, he is instigating other tribal community to take the decision in respect of their forest.
फैसला हमारा. But in India we follow the rule of law, right?
Yes, sir.
So when we are following the rule of law, what is the principle of rule of law?
What are the principles of rule of law? To help you out, we can say that supremacy of law is one of the principles of rule of law.
Okay, sir.
No one is above the
No
law.
one is above
Yes,
the
sir.
law.
So how we can tell फैसला हमारा?
So I would say it was rather an emotional statement than a political one, as he was the tribal head, and thus he
Is
stated
there
that.
any place of emotion in law?
No, sir.
Continue with
Also, we believe that the detention of Mr. Mahavir Arava is unlawful. So, if your lordship permits, I would like to proceed to the next issue.
yeah.
The next issue is whether the doctrine of proportionality applies to the restrictions imposed on environmental and tribal dissent in the context of strategic development. Your lordship, the doctrine of proportionality is used to assess whether restrictions imposed on fundamental rights are justified or not. In the present case, the central government's approval of the Samriddhi Industrial Smart Zone, or as we know it as the SIZ project, and the subsequent crackdown on environmental and tribal dissent, including the arrest of Mahavir Arava, raises fundamental questions about whether the state's action strikes and constitutionality permissible balance between strategic development interest and individual freedom under Article 19 and 21. The SIZ project also claims to serve national interest by enhancing industrial growth and infrastructure. While development is a valid state for the state goal, the suppression of peaceful protest and denial of community consultation are neither suitable nor necessary.
So, what is your contention basically? Is it the contention that the entire project should be taken away, or there is a scope of sustaining the project with a consultation?
So the project can sustain, but as the state is live.
But
Is,
your prior issue was that the project should be taken away.
yes, sir, because there were no prior consent taken by the Gram Sabhas, as we know under the PESA law.
But how come you sustain both the demands? That you want the project to be taken away.
So we
Then
want the project to be taken down.
Now you are saying that the project is possible if it is done in consultation with the Gram Sabhas.
So the
You should make your stand clear to us.
So we want the project to strike down, as almost 35,000 hectares of forest is already demolished, and the
Even if it is discussed with the tribal people and their rights are secured, you don't want this smart industrial zone.
no, sir, we want development, but
How? How you want development? If you are against the project all in all, with no deliberations, with no improvements,
so if they've already taken prior consent from the Gram Sabhas, we didn't have any problem.
then why you are telling that you want to strike down the project?
So as it was proper, sustainable, and there were no consent taken prior, that's why we are stating that they should strike down. The whole project should strike down. As
This is your final statement?
yes, sir.
Okay, proceed.
So the impact of SIZ projects are massive deforestation, displacement of over 40 tribal settlements, and absence of free, prior, and informed consent, as I've already stated earlier. Criminalization of symbolic protest under UAPA, which I've also stated earlier. So these consequences overwhelmingly burden the tribal and environmental rights without showing how such suppression is the only path to national development. And so in this case, Article 21 is also violated. Article 21 includes the right to clean environment and livelihood, especially for forest-dependent communities. So when the forest lands are cleared without prior consultation and peaceful protest of the tribal community is punished without due process, the state fails to uphold proportionality between strategic interest and individual dignity. And thus the petitioner affirms that the restrictions made on the dissent is not at all proportionate nor necessary. So I would like to proceed for the prayer. Wherefore, in light of all the facts and circumstances of the present case, the petitioners humble pray that this honorable court to direct the release of Mahavir Rava on bail, holding that his continued detention is arbitrary, disproportionate, and violative of his fundamental rights under Article 19(1)(a) and Article 21. Declare that the restrictions imposed on environmental and tribal dissent in relation to the Samriddhi Industrial Smart Zone project are unconstitutional and violative of the Article 14, 19(1)(a) and 21 of the Constitution. Issues any appropriate writ order or direction to halt or review the SIZ project until full compliance with constitutional and statutory requirements, particularly the Forest Right Act and PESA and the Environment Protection Act, is ensured. Pass any order as this honorable court may deem fit and proper in the interest of justice. And for this act of kindness, justice, and equality, the petitioner shall ever pray. So, we're done.
Respondents?
Oh, sorry. The council seeks permission to address the bench. Highly obliged. The council wants to address the bench, my lordship.
Highly obliged. I am the first speaker. I will cover the first two issues. The rest of the issues will be covered by my co-team member. If the judges have the idea of the jurisdiction, facts and issues raised of the case, or I may start with the facts or arguments advanced. Let us come to the first arguments advanced. Today, we do not just appear to defend a state. We raise to protect the integrity of constitutional governance, the sanctity of public interest litigation, and above all, the right of a nation to move forward. The appeal filed by Jivan Jagrukta Abhiyan is non-maintainable under Article 32. The plaintiff comes before this honorable court with a flag of public interest, but behind that flag nothing but speculation, political opposition and ideological discontent. There is no injured party, no specific victim, no documented breach of fundamental rights, only abstract fear. My lordships, justice cannot be founded on shadows. The project they seek to obstruct, the SISZ or Samriddhi Industrial Smart Zone, is not a casual commercial undertaking. It is a strategic lifeline envisioned after years of planning, meant to catalyze growth, ensure logistical development, and elevate livelihoods in a region that has for too long remained untouched by progress. Shall the voice of development be forever drowned in the noise of dissent? The plaintiff did not approach the National Green Tribunal, the Ministry of Tribal Affairs or local authorities. They came straight here. Why? Because they want spectacle, not solution. My lordships, this honorable court has always stood tall as a pillar of restraint. In some cases like Balco Employees Union case, in Simranjit Singh Mann case, in Manohar Lal Sharma case, this court reminded us that peals are for the voiceless, not for the political megaphones. The petitioner, though marked as a public-spirited body, has opposed development and infrastructure projects irrespective of their merits. The petitioner has not disclosed affiliations, failed to engage the pre-existing consultative frameworks, and has selectively quoted data to discredit state action. The forum of appeal is not meant for surviving political purpose, for solving political problems where no legal wrong or legal injury to the plaintiff or any identified class of the people is shown.
How can you give a saga of development the color of political issue? What facts here are telling that this is a political issue?
Because the appeal is based on political motives and lacks bona fide. The petitioner's background, affiliations and pattern of litigation show a political opposition to infrastructure and strategic projects, not a genuine concern for constitutional violations. The petitioner has attempted to stall an essential national development project which has passed scientific, environmental and strategic scrutiny.
How the political agenda is served here? What is the political agenda served
He
here?
has been represented as a tribal leader and he has been representing the tribal people's interest, and that is why the public interest has been filed. The court wants to know whether your government is seeing this as a public interest or is a personal interest. Now, if it is a personal interest, you must absolutely establish that there is a political connection. Otherwise, if there is no political connection, your case doesn't stand on the basis of a political abstinency or things like this.
Sir, yes, sir. The appeal should not be used as means to serve political ends or advance publicity-oriented litigation. The motive behind the appeal appears to...
You are telling about the do's and don'ts of the appeal, that it should not serve the political agenda.
Yes, sir.
But what political agenda, or how can you substantiate your view that the political agenda is being served here?
Where is
Because-
the mentioned?
Because the project SISZ is a project that so one second. Sir, in March 2025, the central government approved the Samriddhi Industrial Smart Zone, a project 35,000 hectare logistics and industrial corridor in Varnath.
Mr. Arabia, you are indicating him as a political leader.
Yes.
As per the petitioner concerned, he is the environment activist or the tribal leader. Then why are you pointing him as a political leader?
Because because the background of the petitioner has shows that the show a political opposition to infrastructure and strategic project, not a genuine concern for constitutional violations.
So someone if speaks against the government, you will take that there is political color.
No, sir.
Then how the concept of democracy?
Constructive criticism has always been allowed by the court and the government.
Sir, sir, because the appeal sir, no, sir.
Okay, proceed to the next.
Let us come to the second arguments advanced. The SISZ project does not violate a fundamental rights under Article 21, 19, 1G and 14 and should not be halted on constitutional grounds. May it please the Honorable Court, today we stand at the crossroads between progress and paralysis. The Samriddhi Industrial Smart Zone or SISZ is not a random act of destruction. It is a vision for national progress spread across 35,000 hectares to catalyze trade, infrastructure and employment for
What will
millions.
happen with those people who are staying there, like 32 hectares of land are destructed, deforested? And what will happen with the tribal community or the creature living there?
Sir, ma'am,
Their fundamental right won't get violated.
as SISZ project proposes the development of a 35-hectare industrial and logistics corridor intended to catalyze national infrastructure, trade and manufacturing growth. Such projects does not violate the people's right to life, while such industries are of vital importance for the country's progress as they generate foreign exchange and provide employment.
What will happen with the tribal community?
How would you rehabilitate those tribal people whom you are displacing?
Has the
My
government any second plan for it?
The government, if we no, the government does not have any second plan, but
Also, the
by-
inquiry was not made public.
Yes, sir.
Also, the environmental impact that will be done by this smart industrial project has not been made public.
Yes,
So that itself shows that there is some form of irregularity that is being done by the government.
but sir, this project will feed families, create jobs, bring much needed stability to an underdeveloped region. As Article 30, as Article 14, the SISZ is not a discriminatory project. It is uniformly applied, lawfully approved and
It's a smart city project, right? Then the tribal community will be not that much literate. So how will they accommodate in a smart city project?
Proportionate is this, that the poor people, the tribal people will be displaced and the city people shall be given a luxurious stay at a smart city.
No, sir.
Proportionate is this.
So if you can't, just take time.
Okay.
Give that extra time to your speaker so that she can.
Okay, sir.
The council seeks permission to address the bench. Thank you.
The Unlawful Activities Prevention Act 1967 is not a weapon against the democracy. It is a shield for the republic. It is not designed to silence voices, but to safeguard a nation whose sovereignty has been challenged by the forces of terror, insurgency, and the violent extremism. The Constitution itself gives space for the reasonable restrictions. Article 19 Clause 2, Article 19 Clause 4, and 21 all recognize that liberty is not lawless. Freedom of speech does not mean freedom to incite violence. Freedom of association does not mean freedom to build terror networks. The UAPA acts only where there's a clear nexus with the unlawful or terrorist activity. Yes, UAPA is stringent, but my lordship, terrorism is not an ordinary crime. When bombs go off in a market and children grow up hearing the gunshot instead of the school bells, the state must be empowered to act preemptively, not just reactively. Sections like 13, 15, and 43D, Clause 5 exist not to punish ordinary citizens but to prevent extraordinary harm. The right to bail, the presumption of innocence, and the fair trial are all protected. But in the cases of the national security, the Constitution permits the state to temporarily restrict liberty, provided it follow due process, and the UAPA does. Extended detention, bail, and the designation are all judicial supervised, not arbitrary imposed. Critics cry vague laws, but my lordship, the Honorable Court in the Arup Bhuvan versus K.M. Najim has already read safeguard into the law. Membership is not a guilt unless there is active participation. Speech is not a crime unless it provokes public disorder. Let us not forget Indiana is not alone. Nations across the world, the UK, US, Australia have a comparable stick law. The UAP aligned with our international obligations, such as the UN Security Council Resolution 1373, urging strong democratic counter-terror laws. The plaintiff portrays these laws as an attack on protest, but we ask where is the evidence that UAP has criminalized peaceful dissent in this case. Mahabir Arwa's arrest was not for protest, but for allegedly inciting mass resistance.
Why UAPA and not unlawful assembly? Why UAPA was called upon? Was there any prima facie evidence that this person is involved in some form of crime or criminal activity from prior activities? Why UAPA? UAPA is a very harsh kind of law which is used in special circumstances. Why UAPA has been invoked by your government?
Sir, he is connected with the 3 environmental networks.
Which has been flagged and not banned.
Two of which are already flagged.
Flash, that means it is under suspension. So anybody who talks against me, I will be flagging them. Does that mean that they are banned? Or does that mean they should not be allowed to speak? Or does that mean they are not allowed to be associated with any other person?
Sir, he is allowed to speak, but he is inciting violence in this area.
He was an activist whose certain statements were against the public policy, and he could have been held under any other law. Like if he was encouraging unlawful assembly, he was himself in an unlawful assembly, then he could have been held. But why UAPA specifically? Isn't it vindication from the government?
Nyayapat filed a writ challenging the constitutionality of the UAPA Section 13 and Section 18 for violating Article 19 and 21.
UAPA section are violating Article 19 and 21.
Yes, sir.
So you yourself is dismantling the case. You are presenting for the government, right?
Yes.
You are saying that
No,
UAPA
no,
is
sir.
violating Article 19 and 21.
No, sir.
Therefore, you have made submission just now.
The certain section of the UAPA may impose reasonable restrictions on the fundamental right. These are the permissible under the Constitution and the crucial given
That
threat.
is the scope of UAPA. That we are well aware of. That what UAPA is empowered to do. My question is why UAPA has been invoked in this particular case?
Because
Somebody criticizes the government. Shall they be booked under UAPA?
he is
This
also
should be the standard protocol. This should be the standard procedure.
he is also connected with the environment, international environment.
Does environmentalists make bombs?
There
No,
are
sir.
other laws, no? Why you chose UAPA?
UAPA is specific because it seems to the code that the government is vindicating some sort of voice which is raised, which has been raised against the government. And how would the government defend this?
Sir, I'm not able to answer.
I proceed with your submissions.
Mahabir Arwa's arrest was not for the protest for but allegedly inciting mass resistance and disrupting public order. There is a line between the protest and the provocation, and that line was crossed. My lordship, UAPA is not unconstitutional. It is a constitutional courage. It reflects the vision of our founding father who believed in liberty, but not at the cost of the national survival. The law targets not voices of the concerned for voices of the chaos. We do not silence democracy. We protect its every breath. Let not fear of misuse weaken the state pines. Let not isolated and executed relay the national duty to defend itself. We therefore pray that this honorable court uphold the constitutional validity of the UAPA, not just for today but for the Indiana of tomorrow.
Your statements are a good example of good statements but without law. There is no law points in it, and I'm not finding any law point on which you are supporting your case. I'm finding your statements are very philosophical. You are using philosophical statements which are supporting your case. That is good, but only arguments will not win in the case. You need to provide us with certain law points on which you are fighting the case. The court will listen to the law points, and arguments are just a support of it. Please continue.
I'm starting with the fourth argument. The plaintiff Mahavir Arva is not an innocent protester caught in the web of the misunderstanding. He is an accused under section 1318 of the UFEA for deliberately delegitimizing state authority, mobilizing unlawful resistance, and provoking mass disobedience. His speech sparked not just thought but disorder. Roads were blocked, public transport halted, and classes erupted. This was not a mere protest, this was the provocation. Section 43D clause 5 of the UAPA stand as a high wall. This honorable court in the Gurvinder Singh versus Mangratam Anand Singh has reaffirmed that jail is a rule, bail is an exception in the UAPA cases, especially where accusations are prima facie true. My Lordship, the Constitution permits reasonable restrictions on the speech under Article 19 clause 2, especially when the speech threatens public disorder and national security. The right to free speech does not include the right to incite violence, chaos, or rebellion. In Umar Khalid, Washid Khan, and the Jalaluddin Khan case, courts across jurisdiction have refused bail under the similar ground. Where free speech morphed into fuel for unrest, the court in Kedarnath Singh versus Seyas Singhal has made one thing clear: there must be a clear link between speech and violence. And here, that link is undeniable. Mahabir's words were not mere opinion. They were a spark in the dry air. We do not claim that UAP is above the Constitution's scrutiny. In fact, it invites it. But when a law specially lays down that bail must be denied if there is a credible suspicion of the terrorist or unlawful activity,
Is there any relevancy of section 1318 with the section 66A of IT law?
yes, ma'am.
What is the relevancy?
Online cyber crime.
And what is the relevancy of shares in the case here?
Five minutes left.
In the case of the Shreyas Singhal versus Union of India, the court emphasizes that there has to be a degree of proximity between the word spoken or expressed and the public disorder that takes place. However, in reality, there has been a continued trend where charges of section have been pressed against individuals for criticizing the government. We cannot allow freedom of expressions to become a shield for the destruction of the public peace. The plaintiff is not entitled to bail either under Section 43D Clause 5 or under the protective scope of Article 19 Clause 1 Clause A. Fifth argument. We submit with the greatest respect that the doctrine of proportionality, while a noble principle, cannot be blindly applied when the survival and sovereignty of the nation are at stake. The SISJ project is not just a development, it is a lifeline of the national defense, energy security, and economic autonomy. This is not an ordinary infrastructure. It is a strategic corridor touching the very north center of the Indian sovereignty. Yes, the Constitution protects freedom, but it also grants the state the power to reasonably restrict them for the sake of the public order, security, and integrity. Article.
How is SISJ related to defense?
Sorry, sir.
How is SISJ project relates to defense security?
Defense.
Can you just say it's a matter of defense security as well? Because if you link this to the security and defense thing, then it becomes entirely different case. And if it stays with the only environmental aspect and developmental aspect, it becomes different case. Is there any link?
No. Article 19 was never meant to be a societal pact. Protests have turned into disruption. Peace has given way to provocation. What began as dissent should become obstruction, blocking roads, halting machinery, and threatening officials. This is not protected expression. This is a strategic stoppage dressed at protest. In the case like Union of Indiana versus Amit Ravarthar and Manohar Lal Sharma versus Narendra Modi, the court has made it clear matters of the national security and the strategic policy deserve judicial differences. Court must not second guess executive wisdom where security, geography, and geopolitical interact. Environmental duties under Article 48A and 51A clauses do not override national interest. Even tribal rights under the PESA and FRA for consultation, not veto. Article 47 obliges the state to provide jobs, foods, and growth, and this cannot be held hostage by indefinite protest. Let us be clear: development is not the enemy of the environment. It is a part of ensuring people's dignity, livelihood, and safety. The margin of appreciation, a principle accepted globally, allows states to calibrate restriction based on the local needs and national interests. Therefore, proportionality cannot paralyze the state when it acts reasonably and responsibly. So let's proceed with the prayer.
What is, tell me what is Sachidananda Pandey's case?
Sachidanand,
Sachidananda Pandey versus Union of Indian case. How is it?
last. Sir, I have no idea. In the light of the aforementioned submission, the defendant must respectfully pray before the Honorable Court that it may be pleased dismiss the special leave petition and the public interest litigation as being devoid of merit, uphold the constitutional validity of the relevant provisions of the Unlawful Activities Prevention Act 1967, particularly Section 2, Clause O, 13, 18, 35, 36, and 43D. Hold that the SISJET project does not violate Article 14, 19, Clause 1, Clause G, or 21 of the Constitution of Indiana and is a legitimate exercise of the executive authority in the national interest. Affirm the denial of the bail to Mr. Mahavir Arwa in the light of the statutory limitation under the UAPA and the gravity of the allegation. Hold that the restriction imposed on the environmental and the tribal protest are in accordance with the doctrine of proportionality, considering the strategic and the national security interest involved. Thank you.
Please listen to the question for them.
The respondent. Your Lordships, the respondent states that only the planning of the case has been done, whereas the project has already been approved, for which 35,000 hectares of deforestation will take place. And this will further continue as the urbanization SISZ project will be bringing to the tribal area will keep attracting other projects. Now only 35,000 hectares further, more and more, and this will probably continue, and eventually no further place will be there for resettlement of tribal people and will assist unemployment and discrimination for them.
The next rebuttal is why EIS preliminary assessment was conducted and not disclosed to the public if everything in it was considered legal.
Rebuttals. Your rebuttals are over?
Yes, sir.
Sir, can I take the question? The project has already been approved for which the construction will take place. This will
First contention that they raised is the project is already approved.
Yes, sir.
So there is no question of having a discussion or something like that. You have already approved it.
Hmm.
Why is that? And second is why EIA has been not made public in spite of having all the clearances as per the government. Because these are the two queries that you have made.
So, so So, because it is a feasibility, the state disclosed the project in feasibility studies and so second question. What was the second question? Not getting. Not disclosed of to the public if everything.
The rebuttal should have been noted by the researcher.
Sir can't give the answers. So can I proceed more questions to my?
You don't have the answers for their question, right? You want to
have-
raise more questions.
Yes, sir.
Is that so? Yes. Proceed.
Can the plaintiff deny that strategic infrastructure projects site SIS set area of critical importance to national development and security was can the plaintiff assure this court that such speech did not instigate or contribute to any obstruction of essential services or damage to public infrastructure? And the last question is, has the plaintiff placed sufficient material on record to demonstrate that bail under section 43d5 of UAPA was wrongly denied, or has the plaintiff merely relied on generalized claims?
There will be no more cross. There will be no more submission from this side. The question is
Fast.
question.
Fast question.
No. There will be only rebuttals and sub-rebuttals. Any other rounds are not allowed. You are not allowed to answer. If this is a question because you have raised the rebuttal, they will be answering the sub-rebuttal in whatever manner. They are not answering, but they are imposing questions. That is their sub-rebuttal. That will be held to the court. That will be left open to the court. There will be no more submission from your side.